Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We have 4 cases for argument this morning. First is 23-463 in the matter of the marriage of Carlos and Leticia Benavides from Webb County and the 4th Court of Appeals District. Second is 22-662, the City of Austin versus Powell from Travis County and the 3rd Court of Appeals District. Third is 23-94, City of Houston against Rodriguez from Harris County and the 14th Court of Appeals District. And finally, 22-787, In re JYO, a child from Collin County and the 5th Court of Appeals District. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the arguments, completing them before the lunch break. The arguments are being webcast live this morning and will be available later in the court's archives. We're ready for argument in 23-463.
May it please the court, Mr. Alexander will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, this case presents the court with 3 important questions of first impression. The first one is, in Texas, may a guardian initiate a divorce proceeding on behalf of a ward, as opposed to merely continuing the prosecution of a proceeding commenced by the ward while competent? The second question is, if this court decides that a guardian may initiate a divorce, under what circumstances may that be done? Which brings us to the third and related question, and that is, are there any circumstances under which a court can grant a divorce as a matter of law on summary judgment based on the naked fact that the parties lived apart for 3 years without probing deeper and asking, why were they living apart? Whose decision was it to get the divorce? These are...
What about the mootness question? Is that not a question for us too?
I'm sorry?
Mootness, is that not a question for us too?
It is.
Okay.
It is. And I'm happy to get to that. You want to, I can address that now?
No, well, you just said it presents 3 questions, although you did say
there is a
all
fourth.
Yeah.
There is a fourth. Jurisdiction.
I mean, it seems like we got to deal with that before we can get to the rest.
There is that. There is that, and I'm happy to address that. My plan had been to dive into the merits, given the limited time, but if at any time any member of the court wishes to discuss jurisdiction, please interrupt me.
Well, we're going to spend a little bit of time, I'm sure, with your friend on the other side, so maybe just give us a quick pitch.
Okay,
so
the quick pitch is,
at.
the quick pitch is you need to look at your decision in Dunn versus Dunn. And quite simply, where the Court of Appeals tripped up in this case was by misapplying that. The court did not examine what the rights of the parties might have been if the divorce was terminated by death as opposed to by divorce.
And so because the court didn't do that, and you make a very strong argument, my question for you is, why isn't that 4th issue the first issue and the other 3 go back to the Court of Appeals, which didn't address any of them?
Yeah, exactly. For purposes of my argument, I'm going to dive into the merits, but for purposes of this court, that is the first question. The jurisdictional question.
And to that first question, you seem to say, okay, the Court of Appeals erred, and the remedy is that the parties' marriage is reinstated. And the other side seems to say the Court of Appeals erred, and the Court of Appeals was right, and the final judgment, which was never reviewed on appeal as to the merits, is what holds sway. But it seems as though if the Court of Appeals is examining the validity of the divorce, they're really reviewing a final judgment. And should they look at that before they determine what the estate might look like if the parties were married versus if the parties were divorced.
Well, let me take issue with the word you used, reinstated.
Oh, okay, continuation of the marriage.
Continuation of
Yes.
marriage. In other words, this case presents two very clean legal arguments. One is jurisdiction, clean legal argument. The other is merits, also a clean legal argument. This court can decide to send this back to the Court of Appeals for both of those decisions or one of them. I'm inviting this court not to. I think this court, if it did so, would make the same, I use this word advisory, mistake that the court made in 1988 in the Wallenmeyer decision, where this court became the only court in the country to move from what was the majority rule with respect to guardian divorces to the minority rule with no analysis. So this state is begging for guidance. This court did not give that in Wallenmeyer. It's the only state in the country that ever made that decision without doing it. So back to your point, can you remand this, all of this back to the Court of Appeals because it did reach it? Yes. Should this court do it? I would say no.
Why would it be making that mistake? If we remanded to the Court of Appeals on the ground that it misapplied our mootness doctrine, we're not saying anything about anything on
That's
the merits,
true.
it seems like.
Well, but here's the concern I have about that, is that it doesn't provide any guidance on merits. I mean, let's take a look at Exhibit 2.
Wait, before you get to merits, I'm going
Okay.
to keep you on mootness. So Dunn says that it's moot unless the property rights would be, her property rights would be significantly affected by the divorce as opposed to what she would have by death.
Correct.
And as I understand it, there are 4 property rights at issue. Her standing to participate in the probate proceeding. But the response to that is, well, but she gets nothing in the probate. The 2011 will's already been declared void. I understand that's on appeal. Potential right to take under his will related to that, and that's the 2011. Life estate in her marital home, and that's the issue of whether she waived it in the prenup, right? And then the right to funds where she's designated as a beneficiary or survivor, but she has not put on any evidence that there are any funds where she's designated as a. So what property right would be significantly affected if it's determined that she takes through the divorce as opposed through the death?
The will.
Her rights under the will.
Correct.
So it all comes down to this question of whether the 2011 will is void?
Correct.
Is valid, I mean?
Is valid. And that's, that's going to be a question for another day.
And that's pending in the case that's been
That's pending in the case in the Court of Appeals. It's 04-21-00077 civil. And that has been abated.
So do
And if
you
you go-
concede that she waived the constitutional life estate in the marital home? That you don't argue that that's a property right that would be affected? That's not at issue?
That's not at issue.
Okay.
I mean, really what it boils down to is the will. So there's going to be a ripe, hotly contested will contest, no question, once this is decided. But I urge you
You
to
say
read the
once
brief.
this is decided, in Dunn, we said, the general rule in this and most jurisdictions is that the death of the party to the divorce decree during the time allowed for the appeal does not preclude an adjudication of the appeal's merits. Isn't what you're really just seeking is an adjudication of the merits of the divorce decree?
Yes.
And wouldn't that be the first step before we determine any effect it may have on standing in the probate proceeding or property rights in the one situation versus the other?
Well, that's a great question. I think that, because of the mootness question, I think it's back to jurisdiction. What should you decide first? Maybe I misunderstood the question, but, obviously standing, mootness, all goes to jurisdiction. You have to decide that in order to reach the merits question. And all I'm urging this court, once again, this court has the discretion whether to decide the jurisdictional question. You could just remand on that. You could remand on the merits question. What I'm doing today is to urge you not to do that. I was going to lay out for the court.
So, Kent, before you move on, then under the will, if that's the right she's claiming, clarify for me how it is that if the divorce is valid, if the divorce is upheld, doesn't she still have whatever claims she has otherwise under the will? I mean, how does the divorce change her rights under the will?
Because, that's a great question. Because as a matter of law in Texas by statute, and I can't cite you the statute off the top of my head, but if the parties are divorced, you can't take under the will of your ex-spouse. That's an absolute bar. That's why they were so anxious to get this decided before he died. So that's, again, I think we cite that statute in our briefing. And on rebuttal, I'll give you the cite, but that's black letter law. If you die, if you're divorced, any will that gave you benefits as a spouse goes away, dead, gone.
So if a guardian has the authority to superintend all the affairs of the ward, what other things, are there other things besides this one that you say a guardian could not undertake on the ward's behalf?
Well, I don't know. I don't know.
Entering into divorce might be the only
things.
thing?
What's that?
Entering into a divorce or pursuing
Well, it's
divorce
certainly
might
the only
be the
one
only
I've studied.
thing?
It's
Okay.
another great question. There may be others.
But you've not come across any others in sort of studying the authority of a guardian?
I've not. I think that, the nationwide jurisprudence, which is what I was going to talk about, dealing with guardian divorces is just, that has really been the biggest focus, I think,
And
of
so what
discussion
kind-
as to what a guardian can do.
And so what kind of evidence would be relevant to determine that? Whenever you have the ward who is in a state of being that they just cannot communicate what they wish. So what kind of evidence would be appropriate to reach the level necessary?
Well, thank you. Turn to tab 3, because I think that this is the Boyes versus Edwards case, which is the one case that I think most clearly answers this question, Justice Lehrman, because it is the intersection of both a living apart statute and a guardian-initiated divorce. And what that court says is there's 3 key determinations. One, was when the spouse left the marital home, was that a voluntary act on behalf of that person or was it imposed? So that's one fact question. Second fact question would be, at the time of the divorce, in this case 2020, was it the wish and desire of that spouse to be divorced? But to your point, what if at that point they were incompetent, could not express that? That's addressed here too. Then at that point, it's incumbent upon the court to ask this question: would the divorce be in the best interest of the ward, or would it be in the best interest of the guardian, because they have a financial interest? And that's what this case shows. And that's what's so critically important.
What if it's in both?
I'm sorry?
What if it's in the best interest of both?
Oh, both spouses?
No, of the ward and the guardian. I take what you're saying is in this instance, we have a guardian who has an interest.
Correct.
And so sure, you get that, but what if some other guardian, hypothetically, just parachuted in who had no such interest and also would think it's in the ward's best interest? What do you do then?
Well, what you do then is look at tab 2, and this gets us back to the statute. At the end of the day, this is a statutory construction case. We have a one-sentence statute that uses the critical word may, not must. Then the court exercises discretion. In this case, they acted as if the statute said must. The court in this case exercised its discretion not to exercise discretion, not to make any decision. So back to your point, there could be a case in which the court says it's in the best interest of the ward that this divorce occur. And there's certainly within the case law, you can find examples of that. So we're not up here standing before you saying that it can never be done. To your point, it depends on the facts.
What do you make?
Go ahead.
What do you make of the fact that he had filed for divorce a year after the marriage when I'm assuming he did not, the dementia had not kicked in yet?
It's hard to make much of anything of that. It certainly doesn't matter legally.
Right.
And that's because he ran into, all we know is that a divorce action was filed and that sometime later it was dismissed for want of prosecution. So we don't know the circumstances. Apparently, as best we can tell, they hit a rough spot in the marriage. Wow, that never happens. But that was in 2005. You know, this divorce was granted in 2020, 15 years later. There's no case, and in fact, in this case, I mean, it's very interesting. The Boyd case, you'll see, it was similar. There actually had been a divorce action filed. That action went away. A new action was initiated by the guardian.
It seems to me you're saying, or you're conceding, that if you have a guardian who is interested or conflicted, that it would be appropriate for the court to make a determination on evidence that the divorce would be in the ward's best interest, and that would be appropriate. Do you concede that?
Well, I mean, I can see, I'm trying to hypothecate a situation in which the guardian has a financial interest, and yet the court could still find that it's in the best interest of the court, of the ward. Difficult for me to imagine that, but I am saying, yes, that could be done. What happened in this case is that there was no hearing at all.
Well, so I want to understand why you say that, because both parties, I think, cite to an order at 43 of the clerk's record that appears to me to say that the probate court concluded the divorce was in the best interest.
Did not. That decision was never made.
And supplemented the guardian's power.
Never. There was never a best interest determination. There is nowhere in this record where any court made the decision that it would be in the best interest of the ward for this divorce to occur.
So what is Justice Huddle alluding to then? She's reading.
I think what she's reading from is a dispute as to whether the guardian was authorized to prosecute the divorce. I think that's what you're reading. I don't know.
That's right.
Okay, so I think
It's an order
that-
granting supplemental power.
Supplemental power.
To initiate the divorce. And wouldn't
initiate.
you infer from that order that there was a determination that doing so was in the ward's best
No,
interest?
that's too big of a leap. First off, I think we detailed this in the reply brief. There really was no grant of authority to bring the divorce, but let's even assume that there was. That still begs the question, can you, by summary judgment, get a divorce without shutting the door to all of the evidence as to why it shouldn't occur? I mean, let me
But
give you
I thought your top line position was that the probate court has no power to empower a guardian to even initiate a divorce.
Okay, I'm sorry. No, that's a decision this court has not yet made. So let me
But
be
what
clear on
your-
that.
Your argument is that they can't, right?
No, it is
Okay.
not. Okay, it is not. So this is, I mean, this is one of the unanswered questions. I see I have the red light, but in Wallenmeyer that decided in 1988 stands for no more than the proposition than that the court can continue the prosecution of a divorce.
Right.
And the case to
And
look
here
at.
we've initiate. Here it's
As opposed to
initiation.
initiate, I'm not saying that this court shouldn't hold that a court can't initiate. I'm not saying that.
Okay.
That's the unanswered, one of the unanswered questions. What I am saying is, if this court decides that a guardian can initiate, the court nonetheless has a duty to make a best interest determination.
Any other questions?
other questions?
Any other questions? Thank you, Mr. Alexander.
May it please the court, Mr. Orsinger will present argument for the respondent.
Mr. Chief Justice and other justices, may it please the court. There are two issues in this case, we believe, and I believe the court has identified the first one, and the most important one is jurisdiction, because if there is no jurisdiction to review the dissolution of marital bonds, we don't get to the issue of whether the guardian had the capacity to file for divorce. Our view is, upon the death of a divorce, the appeal of the dissolution is terminated, it becomes final, and is automatically severed. And this was concisely recognized in Justice Lehrman's concurring opinion in Baker versus Bizzle on March 1 of this year, joined by 2 other justices. This is supported by the case law and supported by the United States Supreme Court, the whole concept of divisible divorce. And let me say that one of the rationales was that a marital status is an in rem status determination. This is clear from the case law. And as such, it affects not only the relationship between the 2 parties, but
Well, let me say, what's different about this case in Baker versus Bizzle is that in this particular case, I mean, the issue here, there was not the appeal that was going on. It was the finality of the divorce decree rendition versus signing of the decree.
Correct.
And so that's a difference here, it seems to me.
very much so, Judge. The question that the court considered in Baker versus Bizzle was the trial court's jurisdiction and the loss of the trial court's jurisdiction to change marital status. In this case is death on appeal. What effect does it have on the appellate court's jurisdiction? The trial court's jurisdiction has already concluded, the divorce has been granted. But the principles are the same, Your Honor, that we have a divisible divorce in Texas. Eston versus Eston established that at the federal level. Justice Heck's opinion, and Austin versus Austin established it in the Texas realm. And then we have 2 provisions of the Family Code that have been amended to allow for the exercise of jurisdiction over marital dissolution separate from property. I think there's no doubt at this point that divorce is divisible. And
Wouldn't mootness on appeal, though, usually mean that the judgment is vacated, so you would lose the divorce that the trial court gave you?
Judge, that is the traditional rule, but when you have separate grounds of jurisdiction and you have a status adjudication with the marriage, which everyone recognizes is based on domicile connection, and you have property division or alimony, which is based on personal jurisdiction, they're not the same. So the idea that
So it sounds like you're agreeing that there needs to be some kind of a special rule for the way jurisdiction works in divorces. And they would say the same thing. It's just that you sort of disagree about what that rule should be.
Well, I think from one perspective, yes, divorce is clearly unique. But the second question is more general. Does the mootness that occurs on appeal cause the claim itself to be moot in the trial court? And in some cases, that's yes, and in some cases, that's no. In some cases, the event that causes the mootness on appeal doesn't make the dispute moot. So an appeal can become moot, we believe, without the trial court judgment becoming moot. So I think the general rule may not apply, but yes, I think there's a special rule because of the status adjudication and the separate jurisdictional foundation for divorce versus property division.
Well, beginning with the question of whether it's moot or not, all right, before we get to the effect of mootness, we have to decide whether it's moot or not. And you agree that Dunn sets the standard for that as to whether it significantly affects her property interests. And you've heard Mr. Alexander argue that it does because of her claim under the 2011 will. What's your response to that?
Well, my initial response, Your Honor, is that the right to inherit under a will before death is an expectancy and it's not a property right. So if that's the only thing that keeps this appeal from being dismissed, we don't think it's a legitimate ground. The other issues that she raised in the Court of Appeals, we have 5 summary judgments that were granted in this case. 1 was on the premarital and postmarital agreements, and 4 were on different property rights. They were attacked in the Court of Appeals, but they haven't been attacked in the Supreme Court. So at this point, basically, there's no reversible error in the property division. The question becomes,
Does the right to inherit ripen at the time of death? You said it's an expectancy, but when somebody dies, it's no longer an expectancy, right?
Admittedly.
And so the death is both the event that you say moots the divorce, but it's also the event that ripens the property interest that Mr. Alexander referred to. So how does that work?
Well, if they are divorced by operation of law, Leticia cannot take under the will.
Right, but if they're not divorced, then maybe she can.
That's the whole point here.
And isn't that the Dunn standard? The outcomes are significantly different. If they're divorced, there's no way she can take under the will. If they're not divorced, at least she's got a colorable claim that she can. And so therefore, allowing the divorce significantly impacts her property right. And to me, that means it's not moot. Is that incorrect?
I understand exactly what the court is saying, and so the question becomes then, if he died on the day of divorce and rather than on appeal, is it different from if he dies on appeal? But if the test is whether the outcome would be different today, whether they were married on death or divorced on death, clearly the outcome would be different because she would at least have the opportunity to present her will. And if her will is upheld, then she would actually benefit. But of course, she has to win that battle in the probate court.
And then that says to me, under Dunn, it's not moot.
I think you're right. Under Dunn, it's not moot. The thing about Dunn, I think that's important, is that Dunn connects the dissolution and the property division as if the property division alone determines mootness. In light of the analysis that's contained in the concurring opinion, in Justice Lerman's concurring opinion, it suggests to us that with the divisible divorce concept, the better idea is it really doesn't matter whether you have mootness on the property division or not. The divorce decree, the dissolution itself, is not subject to appellate review if death occurs after the judgment.
If we don't agree with that, and we do think that it is not moot under Dunn, what should we do? Will we proceed and address the merits questions?
It's our view, Your Honor, that this court should resolve the case without a remand to the Court of Appeals. So Mr. Alexander and I agree on that. The points are legal issues. They've been fully briefed. There's no reason to send them back to the Court of Appeals to have them analyze it so that it comes back here to have this court analyze it. We would prefer that the court go ahead and address the underlying issues about capacity of the executor and whatnot, and not without a remand. So our view would be if there is dismissal was inappropriate, then you can consider the dissolution on the merits, which was by summary judgment, and there was no contravening facts. There were just arguments about capacity that were made. So that's a matter of law. You can rule on without a remand. Yes, Your Honor.
So in Dunn, the comparison of the two property interests, what it would look like on death, what it would look like on divorce, was what really the gravamen of the case was about. In this case, the challenge is really to the validity of the divorce.
Correct.
And the principle in Dunn that, if death happens while the time for an appeal is pending, that doesn't preclude an adjudication of the merits, would seem to say, okay, well, you can go back, even aside from comparing the two sets of property rights, you can go back and decide any challenge to the validity of the marriage and the capacity, of the divorce, and the capacity to enter into the divorce.
Well, that would be an inference, Your Honor, but in the Dunn case, neither side disputed the dissolution itself. So the sole issue was whether there was still jurisdiction to consider the claim on the property division. If you were to link the two together, which Dunn did, then if you don't have mootness on the property division, then I guess you don't have mootness at all. And so you look at the dissolution as part of an appeal. But if there's a divisible divorce, and if the jurisdiction over the death that results from the death, the jurisdiction over the dissolution is separate and automatically severed and goes final, then Dunn really is just a question of when do we have jurisdiction to review the merits.
But if we did look at capacity, your argument is, look, we provided summary judgment evidence that we met the requirements of the statute and no contravening evidence about lack of capacity or that it was against the desires of the ward to live separately was raised. And so who has the burden of raising the issue of voluntariness with respect to the divorce if it is an element of or if it is something that a court can look at in determining whether a guardian can proceed with the divorce?
Are you asking about who has the burden in the trial court?
Correct.
Okay.
Because if there was no evidence adduced in the trial court, that matters, right?
Right. Well, what we have in this case is we have an adjudication from the guardianship judge that in 2013, Carlos did not have the mental capacity to make decisions regarding his marriage. So with that backdrop, you have to ask the question of what constitutes consent for an incapacitated person where the guardianship judge has said they don't have the ability to formulate views or opinions about the marriage. So can there be any evidence? The guardian steps into the shoes of the ward when the guardian is appointed. And in our view, the guardian does represent the wishes of the, but it's all
But
subject to the.
it's
it's
so
subject-
sorry,
I'm sorry, Justice, it's subject to the approval or oversight of the guardianship judge. Yes, Your Honor.
Isn't it clear, though, that the guardian cannot cause the ward to get married?
Well, I don't know of a case that says that, and the statute doesn't say that, but I think that that is a plausible position.
I thought there was a statutory indication that that was.
Well, if there is, Your Honor, I'm primarily a family lawyer, and you may know the law better than I do on the guardianships. I'm not aware of that statute.
Well, would it be your position that a guardian could marry the ward off to somebody if the court decides that that's in the best interest of the ward?
Speaking from what I do know about guardianship law, the guardianship law provides for the guardian to proceed to prosecute or defend cases and doesn't say, to my knowledge, anything explicitly about marrying. So the decision about whether the overall powers of a guardian include the decision to marry or not, to me, is not clear from the case law or from the statute.
It seems to be an important question, whatever the answer is. It'd be odd if you cannot cause the ward to get married, but you can cause the ward to get divorced.
Well, to me, that's a legislative decision about what powers do we give to our guardians, and they've clearly given guardians the powers to prosecute cases. To my knowledge, they haven't clearly given the power to marry, but it's certainly plausible. But that points up one of the dangers in this situation. Mr. Alexander is asking this court to lay down a universal rule for all cases on all facts. In reality, the guardianship code is designed for a particular guardianship judge to supervise the welfare of a particular ward based on evidence, based on the appointment of an attorney ad litem like we had in this case, or a guardian ad litem, and a succession of hearings. Each judgment is separately appealable. We've had 24 different appellate procedures in this case. This has been so well supervised. My point is that, is this the area where we want to lay down a universal rule for all people in all circumstances, or do we trust the guardianship judges like the legislature has and let them make a decision based on facts?
Well,
Yes,
best
Justice
interest
Bowden?
is a fairly flexible standard that seems to work well in the family law context. So why wouldn't best interest of the ward be a good standard for guardianship judges to apply in deciding whether to grant the power to a guardian to initiate a divorce action?
It not only is a good standard, but it's the universally recognized standard here in Texas.
And if it wasn't applied here, which it seems Mr. Alexander's arguing it was not, maybe you disagree with that, but if the guardianship court didn't apply that standard, then shouldn't we send it back?
If this was an appeal from a guardianship hearing based on a trial, which we had a trial in the guardianship court, that would be a pertinent question. Is it a pertinent question to raise in a divorce case that's been authorized by a guardianship on a trial?
Well, it seems like it is if there was no authority to bring the divorce action that's before us.
Well,
Because there wasn't a best interest finding. That's what I'm trying to figure out, is do you have to have a best interest finding from the guardianship court to allow the guardian to initiate the divorce action? Seems like, I agree with you, it seems like a good rule. So if we don't have one here, then doesn't that mean the divorce needs to be overturned?
we have two different orders where the court authorized a divorce. We have an order requesting or requiring the attorney ad litem to participate in that. We have two subsequent events by Leticia to overturn all rulings or overturn the ruling that appointed a guardian. All of those occurred in the guardianship court. We don't have that record. The first case was a trial. We had two mental health professionals. One psychiatrist testified that Carlos had a mental capability of a 2-year-old. That record is not here. I don't see how this appeal from a divorce on the record we have is the one to review whether the guardianship judge had evidence to support best interest. But I think we can assume that, can't we? Because if the guardianship judge authorized the filing of divorce, doesn't that impliedly indicate that he believes it's in the ward's best interest? So
assuming that was the standard that he thought that was the standard that applied.
Of course, since we don't have that record and that's not on appeal, to me, you wouldn't There's a presumption in favor that the trial courts properly exercise their discretion. And here we are in an appeal of a different proceeding without the record, without the evidence, and we're trying to say, well, because the order didn't say best interest, that somehow it's subject to collateral attack.
Well, let me ask you, if we
Yes,
were to
yes.
find that the guardian did not have authority to file this divorce, what's your argument for how your party would still win?
So that would be a very concerning ruling, Your Honor, because it would deny access to the courts to an incompetent person who's duly represented by a court-appointed representative. It would present equal protection problems. We have policy arguments, the autonomy of the individuals.
Well, no, I'm saying here. I mean, so what evidence would be appropriate to make that determination of whether the guardian does have the authority to file that?
Well, Your Honor, I don't think it's an evidentiary question because we have court orders that specifically authorize the filing of the divorce. So there's no appeal of the evidence behind those orders. And the question then is there evidence in the divorce proceeding, which would be a collateral attack on orders issued by the guardianship judge? And I'm not sure I'm answering your question. If you can clarify it.
Go ahead.
Will you clarify for me what it is on your side that you see as at stake here? If the divorce is final and valid and unappealable, what does that prevent Leticia from getting or seeking that she would otherwise be able to get or seek if the divorce were not final or valid?
Okay.
What's at issue here? Is it the claim under the 2011 will? Is that what this is all about?
Not only that, Judge, yes.
Because there's a prenup, there's no community property, right, and all that. I mean, that's all, no one's arguing about that, I think, right?
Well, if the divorce is set aside, our summary judgment on the premarital and postmarital agreement is part of what gets set aside, along with 4 other summary judgments on separate grounds to prove separate property. If the divorce is set aside, we lose 5 summary judgments, which means that it's back in trial in the guardian or the probate court.
So you think the issue of whether Leticia has a claim to community property, some kind of community property claim to challenge the prenup or the postnup agreements, that issue is back on the table if there's no divorce?
I have to infer that because one of the summary judgments that was granted by the guardianship court was that those 2 agreements are enforceable. Right. And if you wipe out that judgment from the guardianship court, I think it wipes out the summary judgments, all 5 of them. And so now that means we're back relitigating the same 5 issues in the probate court, apart from she's going to file a will contest, has actually filed a will contest, and try to set aside his prior will with the current will, which would then, she's the sole beneficiary with no alternate beneficiary. So it's not just the will that is at stake. It's also the property rights that are at stake. And if the judgment were set aside after the death and the summary judgments went away, then we have to retry whether there's a community estate. And by the way, wouldn't it be inherent that the community estate accrued between the date of divorce and the date of death? And in an appeal where an appeal could go on, not our case, but an appeal where an appeal could go on for 2 or 3 or 4 years, if the divorce is set aside retroactively after death, then you would have a community estate all the way up during that whole period of appeal.
It seems to me that there's at least a strong argument to be made that marriage and divorce are tied to each other inextricably and are so personal and so intimate. And we're not talking about money. We're talking about what many people consider to be a covenant before God, and as well as a civil status. And if we think about it that way, I mean, how can we ever say that a guardian and a judge can decide for someone else whether that person should be married? I mean, we may look at the situation objectively, and the relationship is deteriorated, and there may other factors that may exist, and nevertheless, it might be in the estimation of many people that divorce is immoral or shouldn't happen, or there's various reasons, personal moral reasons why you wouldn't want to do it. And I don't know that any of that can be subjected to sort of sterile, materialistic best interest analysis that courts are able to conduct.
I completely understand that, and that in fact has arisen in other situations of other personal choices. But think of the ramifications of a legal position on what could be a moral or religious issue, and that is it would be denying wards the equal protection of the law. Of all the people in our society, they're the only ones that can't get divorced. It also, in this era where the rights of disabled persons are increasingly recognized as being important, we say when someone is suffering from a mental incapacity and is incapable of making decisions for themselves, they're going to be treated as a special class.
Part of the marriage oath is to support in sickness and in health.
And
If
that
you bind
marriage-
yourself to that person in that way, and I don't know that I necessarily see it the way you're seeing it, and denying someone in that situation the ability to get divorced when they can't make the decision to do so is that a feature or a bug? I'm not sure.
And let me say that we don't know what vows, if any, were exchanged. This was my client's fourth marriage. And we don't know whether they promised to stay with each other. We just don't know those circumstances. But those promises are moral promises or religious promises, but they're not legal promises.
How about from the perspective of the other side, though? I mean, back to the standing, the mootness idea. Aside from all the sterile discussion, to use Justice Blacklock's word, about, is there a property division, what will change? Is there not something about whether if this were to happen to me, whether I'm a divorcee versus a widower? Whether she is a divorcee versus a widow. I mean, that is something that's of great value to ordinary people, and to say that they wouldn't have the ability to pursue that strikes me as questionable when they were involuntarily divorced. That might be the difference in some of the other cases. So there's that, and then there's the oddity that I think a lot of people would see it as somewhat odd to say that a guardian can use the authority to separate a husband from his wife, and then can bootstrap and say, they've been separated for 3 years, so time for a divorce. Look, the law says they've been separated, so we can divorce, when that separation was the very choice of the guardian and not the ward or the other spouse. Can you talk about maybe those things briefly? I know we're out of time, but.
The guardianship proceeding contained evidence regarding the standard of care that my client was receiving at that time, the ward, and concerns for it, and even the ad litem suggested that he be removed from the home, and he was relocated by the guardian of the person away from the home he shared with Leticia to next door to where my client lived. And she provided care for him, and this was all done under the supervision of the guardianship court with the assistance of the ad litem.
Well, could the basis for a divorce, assuming that we get to the point where that could happen, be something other than separation? Could it be, cruelty or something else? This is the thing that just seems troubling to me, is that the very thing, we now have these 3 years without any chance at reconciliation because the guardian prevents that, being the basis for a divorce. And that's my last question, I promise.
So I just want to call the court's attention. There are 3 different Court of Appeals cases that have addressed this question of the motivation behind separation. One is McGinley versus McGinley, which said that mere living apart is the basis for divorce. Fault or responsibility for the separation is not a material fact. Spray versus Spray, the Austin Court of Appeals in 1963, overruled the contention that immoral conduct precluded the right to a divorce based on the ground it was granted. And Fields versus Fields, which was the Waco Court of Appeals in 1966, said living apart without cohabitation is an independent, no-fault ground for divorce, and I quote, "and the cause of the separation and subsequent conduct of one seeking the divorce are not proper subjects of inquiry," end quote. It's been a long tradition. This statute of living apart has existed for many, many decades. And the issue is it was always considered no fault. The grounds for the separation were considered irrelevant. If you lived apart for 3 years, you could get a divorce. And in fact, some would say entitled to a divorce. So in our view, the idea that you can go behind what the statute says, the statute doesn't ask for reasons, doesn't ask for justifications. The statute just says it's a simple fact. If you've lived apart for 3 years, you can get divorced. It would be to engraft a new provision, a new condition on this to say that it has to be done in the following circumstances. So it's not in the family code. Secondly, I think, perhaps I didn't address the court's full question.
I think you've addressed my question.
Very good. Thank you, Your Honor. Appreciate that.
Any other questions? Thank you, Mr. Orsinger.
Appreciate it, Your Honors. Thank you so much.
Mr. Alexander, I believe you have 5 minutes.
If it please the court, let me start where we left off. Justice Blacklock, your question about this whole personal decision issue, getting married, getting divorced. I'm going to give you 3 cases to look at that I think will help this court grapple with these very important questions. The first one is Flory versus Flory. It's cited in our briefs. The second one is Carbon, K-A-R-B-I-N versus Carbon. And the third one is that Boyd case that I had here. I point to Flory because there the Wyoming Supreme Court in 2023 wrestled exactly with the question you stated. And that is, these are profound public policy questions, and in that case, they said that's for the legislature. We as a court cannot make that determination. Absent express statutory authority granted to a guardian to pursue a divorce action, no go. Now, question whether that can be the ruling here in Texas. I think you would have to back off of your Wallenmeyer decision, where the court went at least halfway across the Rubicon and said, there may be an instance, I mean, if the ward has commenced the proceeding.
It could be different if the ward has given an indication by filing the suit themselves that they want to get divorced before
Yes,
they
well, and
become
this brings me to the Carbon case. So in Carbon, that shows the evolution of the Illinois Courts of Appeals thinking on this. First, in 1986, in the Drews case, the court adhered to the majority rule, which was no guardian divorce, period, which is where the Wyoming court is now. Fast forward to 2000, in the case called Burgess, also in our briefs, the court says, well, if it's initiated by the ward, then a guardian can continue the prosecution precisely for that reason. We have a clear intent, desire of the ward to get divorced.
So in this case, if there is an intent to continue the prosecution, would we go from the time that the husband filed the initial divorce and have to make a determination that when that case was dismissed, he was of his right mind when he dismissed it? Otherwise, would this be seen as sort of a continuum? Because that decision to dismiss the divorce proceeding was made, under some sort of infirmity.
So the court grappled with that in the third case, the Boyd case, and because that was a similar case, there actually had been an earlier divorce proceeding that was dismissed, and yet the court said, that's history, this is now, we have to make a best interest determination. If the ward cannot himself come and testify, it's my wish and desire to get divorced, we have to have a best interest determination. Now, I want to add here, because I need to do a little bit of cleanup in the 2 minutes I have left. Here, the argument has been made that there was no contravening evidence. There was. There was an affidavit that was offered by Leticia. Let me give you the site. It is CR 4, Clerk's Record 4, 2822. She lays out the whole history of their marriage and they're being kept apart. The court ignored that, says we're not going to, let's go to tab 1, because this is really critical.
Why wasn't that fodder for discussion in an appeal from the order of the guardianship court authorizing the prosecution of this divorce?
Go to tab 1, please. So let's make sure we clearly understand, because this whole business of trying to say this is, let's focus on the guardianship, don't focus on what happened here. The only ground requested for the divorce here is in this first square. As a matter of law, the spouses have lived apart for 3 years.
Okay, but that doesn't answer my question. My question was, your first argument is the guardian can't bring this on behalf of the ward unless unless it's in the best interest.
Okay, let me.
I understand this is a separate
No, let me
argument. Are
parse
you
this up.
abandoning the other argument or no?
No. Let me back this up. I don't want to confuse authority to bring the divorce proceeding as opposed to the ability to get the divorce on summary judgment. That's where we are in this case. That's the issue in this
Okay,
case.
so you're abandoning your other issue about whether I thought one of your issues was that a guardian can't initiate divorce proceedings without a finding of best interest, but you're no longer arguing that.
Well, I don't think I've ever argued that.
Okay.
But let's concede that, and again, and this is leapfrogging over Wallenmeyer. It's now saying that you can have guardian-initiated divorce. Let's assume, which is a decision this court has not yet made. Okay, to be clear, back to you, you can still decide, no way, no how, that's extending Wallenmeyer too far. I'm not telling you how to decide that case. I'm saying that if you do the leapfrog, if you cross all the way across the Rubicon and say that there can be a guardian-initiated divorce, you can't get the divorce this way on summary judgment that ignores contravening facts, which establish that, let's assume he's completely incompetent. What possible good does that do the ward? He's been kept apart for what, 7 years? How does the divorce help him? It helps her. She lays it out in her briefing. This is the whole thing. We wouldn't be here with 5 summary judgments, whatever, if it wasn't in her interest that there be a divorce. So the notion that this is moot is bogus.
Any other questions? Thank you, Mr. Alexander. The case is submitted, and the court will take a brief recess.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
Mr. Arce here.